In this training module, I'm going to explain the basics of patent claims. This includes reviewing the difference between independent and dependent claims. By the end of this training module, you should be able to draft simple claims for your provisional patent application. Let's get started. We've mentioned several different types of statutory requirements for your patent application. Several of these relate directly to the claims that will ultimately go into a non-provisional patent application. As a reminder, claims are not required in your provisional patent application. I'm going to teach you about claims so that you have some information about them as a way to prepare you for preparing a non-provisional patent application in the future. I also want you to have the opportunity to put some simple patent claims in your provisional patent application if you want to, because it can have some impact on your foreign filing rights. Basically, some foreign countries give you a better position if you have claims in your provisional patent application, or whatever patent application it is that you're claiming priority to by the time that you file in those countries. So there can be some benefit to having them in your application. There can also be a benefit from the drafting standpoint if you put claims into your provisional patent application. And the benefit is this. Once you start thinking about how you're going to claim your invention ultimately in a non-provisional patent application, it will give you an opportunity to think about your invention and think about some of the perspectives and some of the details of your invention from a slightly different point of view, which will allow you perhaps to make your patent application even better by the time you file it and get your priority date. You'll see that this is actually the process that I've used in our sample tool storage system provisional patent application, where I've ended up, after drafting some claim language, adding another embodiment or another variation to my invention, and also adding additional language to the patent specification to cover the claim language that I've added. I'll show you this in more detail here in a minute. Now back to the statutory requirements for claims. There are several different sections that have an impact on the claim language itself, and we'll look at each of these briefly. Section 101 simply states who is entitled to a patent. Now the patent, of course, ultimately has to have claims directed to these types of things: a new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. Section 101 also lays the foundation for some of the other sections that we're going to look at now. Section 102 talks about the novelty requirement for your patent application. This comes from the language in Section 101 about the invention being new. That's what novel means, as we've talked before. So novelty basically means that your invention was not known publicly prior to the date that you invented it and filed your application. Ways that your invention could be shown to have been known in the public is by a patent, a description, a public use, or a sale or offer for sale prior to the filing date of your application. Note again, as we've talked before, that the important date is the date of the activities happening prior to the filing date of your application. Similarly, but slightly different, is 102A2, which talks about patents and printed publications that have a filing date prior to the filing date of your application. So the activity is not that the patent issues or that the printed publication is published prior to the filing date. It's that the patent or the printed publication, meaning a printed patent document, have a filing date, which would be before, of course, the patent date or the publication date, and that filing date of the patent or the printed publication is the important date relative to the filing date of your patent application. Anyway, we don't need to go into more detail on these, but these relate to your claims because anything that you claim in your non-provisional patent application ultimately will be compared with prior art that's available under one of these two subsections of Section 102. Similar to Section 102, but slightly different, is the non-obvious requirement, which also relates back to the new requirement from Section 101. In this case, it doesn't mean that the prior art has to describe the exact same thing as what you've claimed in your invention. It means that the prior art has to describe something that would show that your invention, including any differences that aren't shown in the prior art directly, would have simply been obvious in light of the prior art. And we're not going to go through this in detail, but this is the other requirement, or the other half of the requirement, to show that your invention is new compared to the prior art that's out there prior to your filing date. Several other sections also apply to the claims. These are all shown in Section 112. We've talked about part of 112 before. These subsections all relate directly to the claims. 112b specifically requires that the specification must include claims that particularly point out and distinctly claim the subject matter of your invention. That goes back to the definiteness requirement we've discussed previously. Section 112c talks about the way that a claim may be written. In this case, a claim may be written as an independent claim or perhaps as a dependent claim. There's also something called a multiple dependent claim that we're not going to discuss because it's rarely used, and I would recommend that you don't ever try to use it, so we're not going to talk about it. What I want you to focus on here is the independent and dependent claim types, and we're going to talk about what each of those means here in this module. Subsection 112d relates specifically to dependent claims. Dependent claims simply mean that they refer back to an independent claim and that they incorporate all of the limitations stated in that independent claim, or that independent claim and any additional dependent claims from which a dependent claim depends. We'll go over this in a minute, it will make more sense. But simply it means that a dependent claim adds one more limitation to whatever combination of claims that it depends from. So, a couple more concepts that are important to note relating to claims in a patent application. First of all, claims, as we've talked about before, set the boundary of your protection. Now, this is applicable to a non-provisional patent application, and you should understand that there's a slight difference between the claims in a non-provisional patent application because those are what get examined, and the claims that you might include in a provisional patent application, which simply form part of the specification, part of the overall description, and are not necessarily the exclusive description or scope of your invention in the provisional patent application. Another concept that can be unique and may be difficult to grasp at times is that claims provide a negative right. They provide the right to the owner of the patent to exclude other people from using what is claimed. That means you don't necessarily have the right to go out and make your own invention because it might include certain aspects that incorporate claimed subject matter from other people's inventions. However, you do have the right, once you get an issued patent, to exclude other people from making what you have claimed and what you've been granted. That exclusive right is referred to again as a negative right, as opposed to a positive right to go out and have the right to make your invention. And as we just mentioned a minute ago about Section 112, Section 112 talks about the difference between independent claims and dependent claims. This is an equation for a line, and in this equation, x is considered the independent variable and y is considered the dependent variable. The reason for that is using this equation, somebody would pick a number for x and then solve the equation for y, which of course depends on whatever the value of x was. Depending on the value of x, y is then considered to be the dependent variable. Well, the same thing kind of happens with claims. You set up a claim that's independent and it doesn't depend on any other claims. And then from that independent claim, you can add on additional limitations or additional dependencies in other claims that depend from that independent claim. This will make more sense when we look at an example or two. So here's an example of an independent claim. Every claim is an individual sentence. It starts with a capital letter, it ends with a period, and it uses grammar to flow through the entire sentence. Here we have a system labeled as XXX, and that system includes or comprises three different parts: part AAA, part BBB, and part CCC. And those parts are listed out with the part names or designations, as well as a designation of the functions, and in some cases, an indication of how those parts are connected or coupled together. Now, every claim has three different components to it. One is the preamble. The preamble is the first part at the top that says a certain type of system, or a certain type of method, or a certain type of composition, or a certain type of apparatus. In this case, the first three words there, a XXX system, is considered the preamble. The preamble is always concluded with what's called a transitionary phrase. That's the second component of the claims. So we have a preamble and a transitionary phrase. The transitionary phrase that you're always going to use, unless you have a very specific reason not to, is the word comprising. Comprising sounds like a word that you might use in ordinary language, and maybe it is, but in the patent world, comprising has a very specific meaning. Comprising is considered an open-ended transitionary phrase, which means that the invention you're claiming includes the things that are listed after the word comprising, but is not necessarily limited to those things you've listed. There are other types of transitionary phrases that you could use that are considered closed-ended, and if you were to use those, then your invention would be limited to the parts that you list and nothing else. Now that might seem okay at first sight, but when you have an infringer or a potential infringer doing something that you've claimed, you don't want to be limited to excluding people who do only the things you've claimed. You want to have the ability to exclude everybody who does the things you've claimed, regardless of whether or not they might do more than those things you've claimed. So, as an example, somebody who comes and makes a system with parts AAA, BBB, CCC, and DDD would be an infringer of this claim. It doesn't matter that they have an extra part DDD that's not listed in my claim, because my claim has an open-ended transitionary phrase, the word comprising. On the other hand, if my claim were to say a system consisting of parts AAA, BBB, and CCC, then my example infringer who has parts AAA, BBB, CCC, and DDD would not be an infringer of my claim, because my claim and my invention is limited to the 3 parts I've listed and can't be considered to have anything else. So anything else that's implemented in connection with those parts would put that device outside of the scope of my claim, and I could not stop them from making the claim. So if you're in the chemical composition field, you might find yourself using the consisting of or the closed-ended transitionary phrases. Pretty much everybody else who's making mechanical devices or electrical devices or electromechanical, electrochemical, or medical devices, things like that, you will want to use almost always, and probably for what you're doing, always use the word comprising as your transitionary phrase. So this independent claim, getting back to the 3 parts or 3 components of the claim, it has a preamble, which is the XXX system. It has a transitionary phrase, which is the word comprising. And then it has the body of the claim, which is the rest of the claim, listed on separate lines in a list format. Part AAA to perform function AAA, part BBB coupled to part AAA to perform function BBB, and part CCC coupled to part BBB to perform function CCC. Now this is a very specific format with the semicolons, with the word and at the end, with the period. This is how I always write my claims, in this format or some slight variation of this format, and this is how I would suggest that you write your claims. However, at this stage in your provisional patent application, don't be worried too much about the format of your claims, because as we mentioned before, these aren't actual claims that will be examined. These aren't actual claims that are required to adhere to very specific standards that an examiner will review. These are simply additional aspects of your specification or your description of your invention. They're put in for a specific reason, but they don't have to comply with all of the technical rules of normal claims in a non-provisional patent application. So this is an independent claim with all 3 parts that we've talked about, and it stands alone. It doesn't require any other limitations, any other language from any other claims. Now, before talking about independent and dependent claims anymore, let's talk about claim terminology just a little bit. This is very similar to the description generator tool that I showed you before, with the Excel program that I provided to you that shows you how you can use a specific term from your description. You can create a more generic word or phrase of that term, and then you can find other examples that fall within that more generic word or phrase. So in this case, if I had an invention that required some type of glue, I would go up and I would say, well, what is a glue? A glue is a certain type of fastener. And I could say, what is a fastener? A fastener is a certain type of connector. What are other types of connectors that might be used in my invention? Oh, it might be a joint or something like that. So I start to walk up the tree, finding more and more generic words, and then walk back down different branches of this tree to provide examples of specific implementations or specific versions of things that can do the functions or have the format that's been described more generically above. We don't need to go into a lot of detail here. This is just for context more than anything to understand why a patent attorney would be so particular with the words that they use, especially in your claims. But at this point, when you're drafting your claims, if you choose to do that, just think about what the words are that you're using and whether the word you've chosen is as specific or as generic or as broad as what you want to actually claim and stop other people from doing. If you are very specific, then you'll be very specific in the types of people that you can stop from making your invention ultimately. If you're very broad, then if you can get a patent issued on that broad language, you'll have a lot more chances of stopping people broadly from using your invention. However, the trade-off is that broader language also has the higher likelihood of overlapping with prior art and running into difficulties getting issued. So this goes back to the balance that we've talked about previously in balancing between patentability and getting a patent versus enforceability and being able to enforce the patent against potential infringers. Now I want to look back at this independent claim for a moment that we looked at before, and I want to do an exercise, what I call diagramming a claim. This is an exercise that can be very helpful in visualizing the scope of the claim that you've actually written down. So once you get a draft of your claim, then I want you to take it and diagram it out. I want you to take each of the parts that are listed in your claim and draw a very rough diagram. Don't think about the thing that you've already created, all of the drawings that you created and described in your specification. I want you to just read the claim language, or perhaps better yet, get with a friend or a colleague and tell them these words that you've put in your claim and have them try to draw the thing that you've just described. In this case, what I would end up drawing from my sample independent claim would be a system labeled XXX, which I would just show with a box. And then I know from the language of the claim that my system has 3 parts, AAA, BBB, and CCC. And I know that AAA is coupled to BBB, and BBB is coupled to CCC. So this simple diagram shows the extent of the physical implementation of my device, although shown with very simple box diagram components. Once you've done this, you can look at your claim diagram and you can review what you've drawn and compare that with what you have in your invention disclosure form to see if they're similar, if they actually cover the same thing, or if your claim diagram actually differs substantially from what you have in your innovation disclosure form. This is simply just a check on what you're putting into your claim compared to what you actually invented and described already in other places in your patent application. Now, this is another example of an independent claim, although this is an independent claim for a method or a process instead of an apparatus or a system, instead of a physical thing. In this case, the method is designated as XXX, and it comprises, or it includes, but is not limited to, the following functions: performing function AAA, performing function BBB, and performing function CCC. You'll note that these functions are the same as what we listed already in our system claim. We've just taken them out and put them now in a method format. The difference between system, apparatus, and method claims is kind of technical, and we're not going to go over that. But the idea is that you can cover your invention from different perspectives, and those different perspectives are almost always helpful as long as you've described them consistently one with another. So if you have a way of making your device in a unique and new way, go ahead and list a method for doing that. If you have a way of using your device, or for a user to use your device in a new and unique way, go ahead and list that as your method. You might find that you have a couple different independent claims in your provisional patent application, and that will work just fine. These are all just additional descriptions of your invention from multiple perspectives. In contrast to the independent claims we've looked at, here are a couple dependent claims, and you'll notice that these dependent claims have one very specific addition that doesn't show up in any of the independent claims. These dependent claims refer back to other claims. So if we had an independent claim labeled as claim number 1, and you'll see a little bit of this in the sample provisional patent application for the tool storage system. If the independent claim is labeled claim number 1, then claim number 2 might refer back to the independent claim by saying the system of claim 1, further comprising part DDD coupled to part BBB to perform a function. You can see that we're referring back to the claim number, and we're also referring back to certain parts or components or limitations that are listed in the claim, in this instance, part BBB. We don't have to reintroduce that here because we're incorporating that by reference into this new dependent claim. Additionally, the second claim on this page refers back to a system of claim 2. Now, claim 2 might be an independent claim, or it might be the claim above that refers back to claim 1. You can chain these together in any way, shape, or form that you want to in your provisional patent application. So this dependent claim refers back to the same system XXX of claim 2 and further defines a certain functionality for part DDD, which is configured to perform an additional function EEE, in addition to the function DDD that's referenced above. So you can see how these claims can chain together, and you'll see that in additional detail in the provisional patent application draft that I've provided to you as a sample. Let's look now for a moment at the template that we provided for your provisional patent application. This template shows a claim section, and like the other sections, provides some instructional language in red. You'll note that this section is completely optional for your provisional patent application. If this part of the patent application becomes too overwhelming for you, which it does for some inventors, don't be afraid of that. Don't be afraid to admit if this is a little bit beyond your capabilities at this time, either because of the difficulty of it or because of the time involved in learning this technical feature of claims. This is a skill that patent attorneys develop over years and years of practice. So I've given you a very brief introduction that might be sufficient to give you a little bit of perspective and hopefully some courage to make a draft of your claims for your invention. However, please do not let this section prevent you from filing your provisional patent application. It's much better to file a provisional patent application without any claims in it, or with very imperfect claims in it, than to not file your provisional patent application at all. I want to stress that very strongly because I've had many workshop participants in the past feel like they want to do this, they want to do a thorough job, they want to be complete in the way that they draft their provisional patent application. But to the extent that that desire hinders somebody from actually filing your provisional patent application, then this whole process would be a waste, and we don't want that. We want to make sure that you know that you can file this without the claim section if that's the best way for you to get your provisional patent application filed and get your invention patent pending status. You'll notice in this sample that I've provided the same or very similar examples of claim language that you can use. Now these are pretty generic, and you might find that these are helpful. Or you might find that the samples in the provisional patent application for the tool storage system example might be more helpful for you. Choose whichever examples are easiest for you to mimic, because that's what I want you to do here. Take the format to the extent that it makes sense for you and simply mimic it and replace either the language in this template or the language in the example provisional patent application, and just swap out the language as much as you can so that the claim then describes your own invention instead of either this generic language or the tool storage system in the example. Let's look now at the tool storage system example and the claims that I've drafted up for that provisional patent application. Before looking at the language, I want to make a note that the language you see here in purple text, yes, I've added one more color to this document. The claim language in purple text is all related to the new language I've added for the claims. And I'm going to show you how I've added that here in the claim section, as well as in some other parts of the application based on the work that I did with the claims. So here I added 2 sets of claims. Each set has an independent claim and 1 or more dependent claims. The first set here is claims 1, 2, 3, 4, 5, 6, and 7. These claims are directed towards a storage apparatus. You'll note that my preamble is a storage apparatus, so it's the physical device. My transitionary phrase is the open-ended word comprising that we discussed earlier. And then the body of my claim includes three different components: a brace, a panel, and a hinge. And I've simply said for each of these components either what they do or how they're interconnected to each other, or both. The brace is configured to attach to a support structure, which in this case would be a wall or something like that. The panel has a planar geometry and defines a plurality of openings through the panel. So that's just saying it's basically a panel with holes in it. The hinge couples to the panel to brace and allow the panel to rotate, meaning it hinges at the hinge point. It rotates relative to the brace in at least a storage position and an active position. And I've perhaps been a little bit too complicated here in the language I'm choosing, but you might notice that the storage position is either the vertical down or the vertical up position of the panel when the panel is in storage and not being used. And the active position is at a horizontal or approximately horizontal position so that tools can be stored through the panel in an upright position. And that's what it says here, wherein the active position facilitates passage of a handle of a tool through a first opening through the panel to store the tool in an upright position. Now, I've been very particular with my claim language because that's what I've been training myself to do for many, many years. You may or may not like this language. You may or may not like your own language that you come up with. I don't want you to stress again about the exact language that you use, but putting your language of your invention into this type of format will help you think about what the actual scope is that you're trying to protect from other people copying. And so you'll come up with some language that's the same, perhaps, as the description you've already provided in your application. And some language you might find is actually new and more precise or simply different from the language you used in your specification, and that's okay. I'm going to show you in a minute how to take your claim language and incorporate it back up into the rest of your specification just to be thorough. So our independent claim 1 stands alone. It doesn't have any other claims that it depends from. It doesn't require any other components for an infringer to infringe this claim. Claims 2 through 7 are each dependent claims, meaning they depend from and incorporate all of the language from Claim 1. Claim 2 is the storage apparatus from Claim 1, further comprising or further including a plurality of panels, meaning it's not just one panel, a panel, it's a plurality or multiple panels. And then Claim 3 depends not only from Claim 1, but depends directly from Claim 2, which means that it includes everything in Claim 2, and since Claim 2 depends from Claim 1, it also includes everything from Claim 1. So these all get incorporated into Claim 3. The storage apparatus of Claim 2, or of Claims 2 and 1, wherein the plurality of panels are arranged adjacent to one another along the length of the brace. And if you refer back to the drawings, this is shown in the drawings, I think it's drawing 3A, where there are multiple single file panels that are put next to each other and could be used independently of each other. In contrast, Claim 4 also depends from Claim 2, which means it incorporates Claims 1 and 2, and further specifies that a first panel is nested within a second panel. This is a separate claim than Claim 3. Those aren't meant to be the same. They're not meant to combine one with the other. They're alternative embodiments of my invention, which is why they don't depend from each other in any way. They both depend from the parent claim and one of the dependent claims, but then are independent of each other at the next level. Claim 5 is similar to Claim 2 in that it only incorporates the language of Claim 1 and specifies further limitations. Same with Claim 6 and Claim 7, and you can go through those on your own time. In contrast to the independent apparatus claims, Claim 8 is an independent method claim and Claim 9 is a dependent method claim which incorporates the limitations of Claim 8. So claim 8 simply takes the functions of claim 1, more or less, although I had to manipulate the language a little bit more because it didn't translate quite as easily as the template claims in my template. But you'll see that claim 8 is a method that requires rotating a panel and talks about what the panel has, the geometry and the openings, from a storage position to an active position. So that's all listed in some form in claim 1. It also requires positioning a yard tool having an elongated handle through one of the plurality of openings through the panel, which is similar to claim 1 but is a little bit more precise with reference to the yard tool and the elongated handle. And then the last sentence of the claim requires resting a first end of the elongated handle on a surface below the panel, which is not part of my claim 1. So it's slightly different in scope than claim 1, but at this stage I'm perfectly happy with it. I don't need to refine it more. It explains at a basic level what my claim does, how it will be operated or used by a user. And then claim 9 goes into a little bit more detail about the operations of the panel from claim 8, specifically engaging a mechanical bind between the elongated handle and opposing sidewalls of the opening, which is a more technical way of saying that the panel falls down and binds against the handle holding the panel and the handle of the tool upright together. So you can spend more of your time going through these claims if that would be helpful. Looking at the format, looking at what I've included, and perhaps what I've excluded from the claims. I've tried to be very basic in putting only the language in there that I would want someone else to have to do in order to be an infringer, and not putting extra language in that would require them to do extra things and make it more difficult for me to claim that they're infringing my claims. So let's go back up now and look at how the language in the claims has impacted the language in my specification. First of all, I created 2 additional paragraphs in my specification that simply repeat in paragraph form the language that I have in my claims. I literally took my claims, copied them from where they are, pasted a copy up above at the end of my specification, and turned those claims into paragraphs. The first paragraph here is all of the language from the first claim set, and if you read those claims and read this paragraph, you'll see that I've simply switched the language as little as necessary in order to put it into a paragraph format. The second paragraph is the exact same thing except for the method claims 8 and 9 instead of the apparatus claims 1 through 7. Now the other thing I want to point out, and this doesn't have to be part of your process, but for me as I was writing my claims, I determined that there was actually another way that someone could make a version of my invention that was different and perhaps in some ways better than the versions that I've already shown and described in my patent application. So I went back and I added one more figure, figure 10, and then I described that figure in both my detailed description section, which you see here, as well as my brief description of the drawing section up above. And that's this language here in purple. So I added figure 10 because as I was drafting the claims, like I said before, you might use the opportunity to draft your claims and to diagram out your claim language and realize that there might be some other ways to write certain parts of your application or implement certain embodiments that are slightly different from what you had done previously or what you had explained previously. In my case, the language that triggered this new drawing was the language in Claim 1 about a plurality of openings. At first, I drafted this claim and I said that the panel has a planar geometry and defines a plurality of holes. And then I thought to myself, they might not actually be complete holes through the panel, in the sense that they might not be a hole surrounded by panel 360 degrees. It might be an opening that perhaps is open or isn't surrounded on one side. Let me show you what the figure looks like so this makes sense. Here's my new figure 10. You can see that this is sort of similar to the diagram that I showed in one of the earlier figures, with 4 separate panels adjacent to each other and each one had 4 or 5 holes in it. In this case, the whole language might be too restrictive, and that somebody might want to make a version that has an open whole, or simply an opening through it with an opening on one side. I wasn't sure that I wanted to call this version a whole, so instead I used the term a tool opening, and I used the word opening in my claim instead of whole. I think that has a slightly different meaning. You don't necessarily need to take the opportunity to draw new drawings and add new description into your specification when you're drafting your claims. But you might find it makes you think of your invention in a slightly different way because you're thinking about the exact language that somebody might have to interpret in order to figure out if a competitor is actually infringing your claims. It's simply an opportunity. It's something that I do out of habit from many, many years of practice. Again, don't let this type of behavior that I'm doing make it more difficult for you to get your patent application completed and filed. Your top priority is to complete and file your patent application and get your invention patent pending. And you can do that without revising your claims and without creating new drawings and without even putting claims in your patent application if that's the easiest way to do it. So I want you to make sure that you have enough confidence in your process that you're going to move forward either way, with or without claims, with or without additional drawings. As long as you've met the basic requirement that we already talked about of teaching somebody how to make and use your invention, enabling them to make and use it with a description that makes sense, that will be sufficient for your patent application. If you decide that you would like to try writing claims or to try to put a few claims into your patent application, I say go for it. It's not going to hurt your process. It might help. It might help you think about your invention differently, but it's certainly not going to hurt it, and you should give it a try if you want to and feel comfortable doing that. And that's it for this module. You should now be able to draft some simple claims for your invention to include in your provisional patent application.